Hi, good morning, and hello to everyone. And thank you all for joining us on this podcast where we intend to educate our listeners and our viewers on how we could balance immigration, employer compliance, both from Canadian and the US side. Today, I welcome my guest, Leona Wilson. She is the president of Armillary Business Group Corporation up here in Mississauga. We also have David Nachman joining from New Jersey. He's the NPZ Law Group. Thank you both for joining and taking out time to educate our listeners and to share your experience with our listeners on what's going on the immigration landscape. Today, our topic is going to be on audits, what to expect if the employer has someone knocking on their door, the employees, if they are keeping their documents up to date, or whatever we can expect such employer compliance to be. That's what we are going to discuss today very quickly, what they should be taking care of when they are hiring temporary foreign workers at their premises. Who all are involved? That's very important. To begin, Canadian employers can hire temporary foreign workers for any temporary jobs under various programs such as employer-specific work permits, International Experience Canada, caregiver programs, global talent streams, and so on and so forth. Now, such programs are regulated through Immigration and Refugee Protection Act, and the Immigration and Refugee Protection Regulations. And these are administered in partnership with IRCC, which is Immigration, Refugee, Citizenship Canada, and the CBSA, Canadian Border Service Agencies. Now, Employment and Social Development Canada also comes in picture, and this operates through its Department of Service Canada. They assess applications from employers requesting permission to hire temporary foreign workers. They also conduct labor market impact assessments, which is LMIA, to find the likely effect of these workers would have on Canadian labor market. So this is a structured, well-formulated, and ESDC, which is the Employment and Social Development Canada, watches out very carefully if the employer is maintaining their conditions of employment on which they hired the temporary foreign workers. Leona, do you have anything more to add on to this?
Yes, thank you. The record-keeping part is very important. And what I find is that for many employers, there isn't enough of a structure in place to keep everything in alignment. So first and foremost, when those offer letters are going out, just as a reminder for everybody, we are not able to determine whether or not an individual is a temporary worker until after they have accepted. It is only after the individual has accepted their offer of employment that we can ask for the social insurance number. If we see that the social insurance number starts with the number 9, then we know there is a work permit that needs to be attached to that. And at that point, the employer should be asking for a copy of the work permit and reviewing it to make sure that the individual is actually permitted to be employed in the role in which they have been hired. In most cases, the answer is yes. From there, the best practice for the employer is to make sure that they're keeping a copy of that work permit on their computers, paying particular attention to the expiration date, because we cannot keep somebody employed beyond the expiration date of the work permit unless the employee has applied for an extension at least 30 days beforehand. And if they can give us a screenshot or some kind of an evidence that they actually did undergo that process, then in that case, as an employer, we can continue to employ the individual. Having said that, assuming everything is in order and we're able to hire this individual who's on this temporary work permit, we then, at least in the province of Ontario, are required to make sure that we provide them with additional documentation that's coming from the Ministry of Labor. And so we need to be able to evidence to somebody from Ministry of Labor that we did, in fact, provide that documentation to the individual. And this is really just to outline the rights of the individual so that they have a little bit of a better sense of protection, because there is the feeling that there are some employers who take advantage of individuals who are on temporary work permits because individuals clearly are not so familiar with all of the laws as we should be being here. The best way to evidence that is to make sure that we send it by email and then take a copy of that email or save a copy of that email to the employee's file. So in some cases, employers are using digital files. Keep a copy of that email in that employee's file. And so if requested, you can say, yes, we did send that to the individual as soon as we found out. I would say for the work permits, I find that these things are not always very well handled on the company side. One thing that I always recommend is that when we're saving that file, we have the employee's name, WP for work permit, and then EXP with whatever the date is that it's going to expire. And that way, as soon as you look at the name of the file, you already know when that work permit is going to expire. It's a little bit of a mess going through a folder and having to open each and every one of them to try and determine that. So just for efficiency, that's part of it. The record keeping, though, goes well beyond that.
I would just jump back to one of the topics that you touched is the employer compliance. Now, all employers of temporary foreign workers can be audited by IRCC, ESDC to ensure that the employers are complying with the temporary foreign worker program under which these employees were hired. Now, inspections can occur anytime during 6 years following the first year of foreign workers' employment period pursuant to their work permit. This is also very clearly mentioned during the inspections when the employers receive such correspondence from ESDC. Now, it's very interesting to note, Leona, that inspections can be triggered in many ways, and primarily it could be a random selection. There are odds of 1 in 4 employers being selected. Then there could be a reason for a reason that the ESDC suspects that there's a non-compliance. This could be based on any complaints received from the employees, etc. And importantly, if employer has been non-compliant in the past, then they could be again inspected randomly or with prior information. It's again very important to note here that they do not, if the inspection occurs, they do not require any prior information to be sent out to the employer for any on-site inspections. They could be just randomly showing up at the premises and do an audit of the foreign worker that the employer has hired. Now, very quickly, I'll also add here that the documents that the employer should be maintaining in their HR folder, which I highly encourage my clients, have the employment agreement right there, signed and dated when the initial work permit was submitted. Now, if there was an extension of the work permit, do the process all over again. Get that employment agreement signed. Any changes, it should reflect on the employment agreement because by and large, that is what the guiding rules are going to be for the employee when they continue to work with the employer. Pay slips, they are very important. There cannot be any cash transfers to the employee. It has to be pay slips properly indicating what the wages are as per the employment agreement. That should always indicate the pay slips should always be according to the agreement of the wages. It would be higher, but never ever lower. Now, proof of providing foreign workers' rights. That's so important, Leona, that on the first day of the work or even before they sign the agreement, this is something that they should already be informed of. And of course, they should have the proof of hiring the foreign worker. Their work permit should be there, evidence of employer being in good standing. This should all be well documented. It should always be taken care of. There cannot be any surprises. Because if anything turns out that the employer has not been maintaining, then this just turns out to be a bad reflection and turns out much more complex and messier. I'm just going to turn it over to David and see what he has to contribute on the US side.
Well, it's really good timing, Gagan, because I was thinking as you ladies are speaking about how things obviously are changing from a cross-border perspective. And I'm wondering, and I don't mean to throw it back to you, obviously I have some great information to share on the US side, but what I'm wondering is whether you've seen an uptick in the enforcement arena on the Canadian side. Because here in the United States, we've obviously seen a dramatic uptick in enforcement. We see more and more I-9 audits, and we'll talk about that because, Leona, I've learned so much from your presentation. I thought that there was something like an I-9 in Canada, but I guess there's not. That's really interesting to me. I wish I only had to deal with an email because it seems to me like we have this, it's incredible. We have this manual, which is 130 some odd pages to describe how human resource managers should document the employment eligibility verification of employees, and then to maintain those documents, for which they, if they don't properly do this, they can be fined thousands of dollars. So if the government goes in and does an audit, Immigration and Customs Enforcement, which is a subdivision within the U.S. Department of Homeland Security, if they go in and do one of these audits and they find a substantial number of I-9s that have not been done properly, each one of those I-9s is worth thousands of dollars in penalties to the employee, to the employers. And so deterrent involved in them making sure that they do this, because if they don't, they could end up paying fines, huge fines to the U.S. federal government. And that's only one part of the auditing process. Immigration enforcement that we see in the United States, we have government officers going in and issuing warrants. There are judicial warrants and there are administrative warrants. Administrative warrants are more in terms of going in and checking for I-9s. That's like an administrative type of investigation or audit. But then you have these judicial warrants where the government's now going in and looking for specific people who are not authorized to work, but also might have criminal backgrounds or might be public safety issues. So in the United States, there's been a dramatic uptick in the need to educate employers on the importance of understanding what can happen when the government comes in with regard to audits and investigations. And where we start when we go out and train is to educate the human resource staff, or to educate the person who's at the front desk, so that they understand where the investigation's coming from. Because in the United States, it can be so many different agencies. It could be that they're coming from the Department of Homeland Security. It could be that they're coming from Department of Labor, in which case it's usually a payroll issue. Or it could be the IER, the Immigration Employee Rights Organization, which deals with, like Gagan was mentioning, discrimination on the basis of citizenship or nationality, where all of a sudden the tables have now turned in the United States, and the concern is about not that you're hiring foreign nationals to displace U.S. workers, but it's more like, what is being done to discriminate against U.S. workers by hiring foreign nationals. So it's really kind of interesting. These are all concerns that are percolating in the United States. There's been a tremendous uptick, and this area of practice has really become a hot area.
No, what you're saying totally makes sense. But we may not have those lengthy I-9s, etc., but then the road is going to end the same way as it does in US. We also have huge penalties for the employers not in compliance. We also have the employers are not only penalized, but they are also listed on the government website that these are the employers who are non-compliant. And then those are the employers who cannot hire foreign workers. And they'll always be in very, very close radar of the government authorities. And on another part, yes, they are vetting whether the US citizens can be hired or should not. There should not be any discrimination against, or the foreign workers should not be hired over the US citizens. And I think it's the same on Canadian side as well. When we do an LMIA, Labor Market Impact Assessment, that's literally right in the beginning of the process. They are vetting why a Canadian citizen is not being hired for this position. And that could be one of the reasons that our low-wage LMIAs were frozen for about 2 years, and they will not be active till about another year and a half more. So there are processes. I always feel it's quite parallel. They may be called something else in US, something else in Canada, but the end results are always that we want more and more Canadians to be hired. The jobs should be within the country. That impacts even sometimes we see farmers also. Those are the ones who get non-skilled workers. They are the ones who get really impacted by any of the government regulations, policies, their new pilot programs or their guidelines that hire more Canadian citizens, permanent residents. And on the same note, we have our immigration level plan for 2025, 26, 27 for coming years, where the government has already laid out that the immigration will not be more than 5% of Canadian population. So that includes study permit holders, work permit holders, and then they don't want too many permanent residents also in next 2 years. So they do go through the same processes. call it differently, but yes, we are in the same game.
So Gagan, you and I always talk about the fact that, like the Canadian immigration laws are young and they're growing, and it's kind of interesting to
Yes.
see. I wonder where ultimately it will go. Will it go in the direction of like the Immigration Reform and Control Act and having, a formal paperwork, having a formal document that needs to be filled out and retained by the employer? And I thought that Leona made a great point. Obviously, record keeping here is critical in all respects, and making sure that things are documented. We're now confronting so many challenges here in the States because the immigration law policies are changing on a daily basis. And like, for example, with TPS, which is temporary protected status, we have stuff going on in the courts where people are authorized to work, then they're not authorized to work, and then they're authorized to work. So it's going back and forth every day, and it's changing, and it's driving human resource folks crazy because they're trying to figure out how to document this on these I-9 forms. But you're absolutely right. I think it's a great point about how absolutely critical record keeping is, and just doing the best you can to keep up with it.
I was going to say, you made a good point about people being able to come in when they're doing their enforcement activities. I think many employers don't realize that from Ministry of Labor, as well as from IRCC, they have search and seizure powers. They tend not to seize records unless they feel that there's going to be an issue with somebody maybe trying to hide something, but they have the ability to come in at any time to talk to anybody that they would like, to look at anything that they would like to look at. And as an employer, it's best practice for you to have everything at your fingertips so that no matter what comes to you, you're able to provide those documents very quickly, because what you don't necessarily want is for somebody to be sitting down and say, well, okay, here, you look for it, and letting them go onto your computer systems. You want to be able to pull the records, print the records, provide it to them without them necessarily coming onto your own systems. The exception here would be around the payroll tape audits that we see through ESA. Generally, they will give advance notice for this because they are asking you to pull many records. And what that would look like here is, of course, they're going to look at the offer letter, particularly if there's been a complaint from an individual. That's usually a trigger, not always, but often. And in that case, they're going to want to see the offer letter. Then they are going to want to take a look at the payroll registers. Then they might want to look at the pay stubs. And they want to make sure that everything is in alignment. They also want to see the schedules. And one thing that comes up very frequently that many employers are not seemingly on top of is break time. In all of the provinces, people are to have mandatory break times after they've worked for a certain number of hours. What many employers have done is they've set up sign in, sign out, but they don't necessarily show when the person has had their lunch. Or we've had some employers that are using biometrics, and the biometrics are just programmed that if the person is there for a full day, they're going to cut out a 1 hour lunch period or a half-hour lunch period. Ministry of Labor is not okay with that. They actually want evidence that the individual actually did take their lunch break. So a 4-punch system, you come in, you sign out for lunch, you sign back in after lunch, then you sign out at the end of the day is preferable. They will be looking at record keeping for overtime as well. In particular, that employees have a method by which they can report overtime and that the overtime has been paid out properly. In Ontario, we have overtime averaging, where it can be averaged over, for instance, 2 pay periods, or people can bank overtime for a period of time, but these documents have to be in writing. An employer can't just say, oh yeah, by the way, that's what we do. No, the employee has to agree to it, and the employee can opt out of that and go back to whatever they were doing before at any time. So it goes a little bit deeper. If somebody comes in, for instance, from Ministry of Labor, they're not going to stop there, because Ministry of Labor looks after health and safety as well as Employment Standards Act. So they're going to want to take a look at the safety bulletin board. It can now be an electronic board. So the thing is, does every employee have access to this physical space or this digital space where they can see the mandatory policies, where they can see the Occupational Health and Safety Act, where they can see the mandatory postings that are required. So this is an important element that needs to be in place for individuals as well. And the rules are that for some of these policies, some of these programs have to be reviewed on an annual basis, which means that if there are policies that are posted, then those policies need to be within the last 12 months. And when they come in physically on site, you can see them every time. They're scanning the document. Where's the date? Is it within 12 months or not? So these are all important elements that go beyond the employee record keeping to what is the employer doing on a macro basis for their employment group.
And Leona, it's a really good point that you just kind of touched on. I just want to highlight, and that is that it's what I call the can of worms that gets opened up, because if they're going in and they're looking at, let's say, payroll, that doesn't mean they're just looking at payroll. They're now looking at all these other issues. And then there are other administrative agencies, at least here in the States, where they can refer across. And they're doing that. They refer to these other administrative agencies, and that's where the can of worms gets opened up. And then they're checking health and safety. They're checking. So that happens also when they come in to do what's called a OFCCP audit here in the States, which is federal contract compliance. And then all of a sudden that opens up an I-9 issue. And then all of a sudden you're looking at I-9 issues, you're looking at IER issues. And so it's so important for employers just across the board to be mindful of how important it is to be focused on their records retention policies. It's a great point.
Now, listening to Leona, I'm also thinking about how we always talk that government love paper. They want to see so much of paper trail. They love going through it. And HR work is obviously always so overwhelmed, keeping up to date with all those dates, all those emails that were sent out, especially with any information update. We recently had a wage change. So yes, if at 2025, your wages are different from when you were hired. So are you keeping in compliance? Is there something that the HR needs to jump in and make sure the employee are keeping up with their new changes, etc.? So it just becomes very, very, very critical. And I also want to quickly add here that in case the employer is picked up for an audit, what do they expect? And they can expect a letter to begin with from the Government of Canada requesting documents, information from them. This is clearly outlined by the legislative authority under Section 209 of IRPR regulations to make such requests, purpose of conducting the inspection, timelines for submission. So the letter clearly outlines what they are expecting, their authority under the regulations under which they can ask the employer to provide this kind of documents and information. And it's usually about 2 weeks. That's the time that's given to the employer. So imagine if you're not organized and if you don't have those documents, 2 weeks will be too less for you to gather everything write those emails, which could be 6 years ago or 5 years ago. And then you are in a bad situation. That's how it's very, very important to keep in mind everything for the employees that you're hiring, keep all the records for you. Sometimes we've also seen that we can run an audit for them as a law office. We can always ask our employees that we can just do a drill and we can go through all your foreign workers who you've hired and go through your HR folders if they are all updated. Take time right now rather than it's too late.
This is still probably actually a really good time just to also point out to any HR folks who are viewing this webinar, how important it is also to understand that AI is being used as a tool by the federal government. And there's now a new opportunity to crunch big data and to find inconsistencies. And that opens up an increased possibility of audits for employers. So this is sort of waving a red flag to help employers understand, again, how important it is to mind their record-keeping responsibilities.
That's a great point.
Yes, exactly.
Thank you. I make a good one every
No,
so
I was
often.
actually somewhere where they say that the employer has to make it very clear in their recruitment practices if they are going to use AI to screen the candidates right in the beginning of the process. So out there, you cannot hide anything or do something without informing. It has to be up there, black and white, during the recruitment process also, I was like, okay, that's really up there where the policies and the government wants to ask and be very clear right in the beginning if AI was used.
I think also, Gagan, you had referred before, you made a really good point, and you said that the way that these audits happen is that individuals, employees, could say something, could be a tipster or a whistleblower. But I think my biggest concern is more competitors. And that was something many years ago that reared its ugly head, is that if a business has a competitor and the competitor says, oh, you know what, that employer is not doing their record keeping properly, then all of a sudden the government goes out and does the audit. And I don't know what checks that the government might have in place. It's always concerned. We refer to it, I guess, as a poison pen letter. I'm always concerned about those poison pen letters and what the government might do, because we know that if the government gets a tip, are they going to pursue it? How legitimate is that tip? If it's from someone internally, then obviously it's viewed one way. If it's from, let's say, someone outside, then how is that viewed? So those are always things that I guess that's the kind of thing that keeps me up at night, thinking about how I can best protect my employer clients.
Yes, internally, I don't think we have enough information how the government will use an information put up by a competitor or another employer who has nothing to do with you, who has no business with you, who does not even know. Maybe who knows whether they know about your business or not, or they're just doing it just to make a big thing out of it.
Exactly. And we also have here in the States, we have H-1B audits. They're called site visits for temporary workers, and going to what Leona was saying before, where they check about the hours that a person has worked, with regard to the audits that are done through site visits. And also my biggest concern when they come and do those audits is that they have the right to take pictures. And then the question becomes, what are they taking pictures of? Is there confidential information that they're taking pictures of? So I get very concerned about that. And what we do is we try to train our HR professionals who might encounter an auditor or an investigator who's coming to do a site visit to ensure that everything is covered up on the desks when they come to take pictures of the site. So these are, sort of, I know we're getting into the weeds here, but these are very important training issues that come up when we're training folks who might interface with investigators. So going to, I think what you had mentioned about the hours that individuals worked, here in the States, it's just to ensure that the individuals are not being treated differently than U.S. workers. So I don't know that they have the capacity to get into the actual hours that the individuals have worked. It's kind of interesting. It might be something that we see in the future now that there are better software programs for record keeping. They might actually get into that. But, I have not seen that in the DOL audits, the Department of Labor audits that we've been involved in. Thank goodness, I guess. So.
Well, here, some of our work permits, they restrict the number of hours an individual can work on a weekly basis. So we have to make sure that we're in continual communication with our managers to make sure an individual does not exceed those hours, because that schedule, that pay stub, that's going to come up, and we will be in violation if we allow somebody to work more than what they are permitted to work. So for us, that's been a factor, I think, all along.
And going back to David's point on taking pictures, I don't think, Leona, you will have to tell me if you've had any experience where during the audit they went in and took pictures. I don't think they do it over here in Canada. In fact, in our communication from the government authorities, they always say redact all the confidential information. It's so important. It's so paramount that they do not want to have that information. All that they are concerned is the employee, the wages, the conditions under which they were hired. They were hired as manager, but not doing a work of a chef. So they have to just totally be sure that what they are hired is what they are doing, because when those on-site happens, and those can happen at restaurants or business premises, which are warehouses, etc., where they can definitely show up and they don't need any prior warrant, any notice to be given to the employer. So it becomes so important at that point that do what you're telling the government that the employee will be doing and not come up with something else without informing the employer and following a proper course to it.
One of the very frequent questions I get when I lecture on audits and investigations here in the States is, what industries do you find these audits and investigations happening in the most? I can tell you that we find it here in the States in the hospitality industry, in the warehousing industry, in the cleaning industry. So those happen to be the top three here in the States. But I'm curious to know, in Canada, what would be the top industries or businesses that you see these audits and investigations happening? And we'll assume, at least for the sake of this discussion, that these are random.
These are random, and I think it's going to be more even the IT industry. Now that they've asked that everybody come back to work and no more of hybrid unless the employer is giving that leeway to the employees, I'm going to think that it's going to be now anyone, basically, because if it's now back to work, and we recently heard big companies out here in downtown Toronto asking all the employees coming back in September, take care of your daycare responsibilities, everything, come back. And of course, that would benefit the economy when everybody is going back to work. They are going to move the economy further up in spending and in using these restaurants, which are those downtown restaurants. So yes, coming back to the question, if it could be a random audit to any industries, these are, of course, the favorite ones. The ones that you mentioned, it would be favorite ones in Canada as well. Leona, do you want to add something?
Yes, I was going to say, with Ministry of Labor, they will sometimes pick specific industries, or they will pick specific geographic areas. Or, quite commonly in the summer, they're going to be doing some additional diligence around young workers that are just coming into the workforce for the first time. So it can shift around depending on where they feel like they need to brush up on their enforcement activities.
Interesting. And I think what I'm going to do is, just as I'm thinking about it, I'm going to add to my list also the EV, electric vehicle, on account of what happened last week, at the Hyundai factory here in the States.
Oh.
So although we have, I don't think, at least as far as I can remember, that's generally not where they go. So this was kind of an aberration. Yeah.
Yes, that's a lot going on. And thank you so much for that wonderful insight, David. Thank you so much, Leona, for your time, for those insights. We are all trying to come together, put some time together in educating our listeners, telling them how it's always good to prepare themselves in advance rather than when they bump into the situation. And it's so hard. Sometimes it's so messy to get all the documents, to put all ducks in a row. It's so hard. So thank you very much again for your time. And we look forward to seeing again for another informative podcast next week. Thank you.
Thanks for having us.
Thank you very much.
Thank you.